I know the question may sound banal. My case should be very simple, following what you say. The Bengalese citizen in Italy married in a Muslim marriage. The wife is in Bangladesh. In Bangladesh, there are three different property regimes according to religions. So, Muslim act, marriage, separation of property practically. This individual is going to sell through a mortgage. Is it enough for me to have the certificate, the foreigner certificate, and in the future this is subject to opposability? It has a third-party effect. Auto microphone. But there is no marriage agreement or marriage deed. While another similar case had a spouse that came to me, I had a separation of property, and the problem was solved. But the wife in this case is in Bangladesh, and she's not going to move from there. Have you got a marriage certificate? And you can show and prove that they are married. Auto microphone, sorry. I'm comfortable because Muslims are by religion in a separation of property. Can he be the only one to go through the mortgage for sale? I do not know the Bangladesh regime. But for example, maybe for movable property, use lex recite, as it happens with common law countries. In this case, the Italian law could be applicable. And in that case, the other spouse should act in for the mortgage. If the regime does not establish the renvoi to lex recite, this could be a personal thing, but it depends on the provisions. They were married, they got married before the 29th of January. This is important to see if you are subject to regulation or not. So before and after regulation, because I'm getting lost here. Before regulation, the 29th of January 2019, you apply the law of the common citizenship, but there can be a renvoi. If they are post implementation of the regulation, is the law the first habitual residence, which is Bangladesh, with no renvoi. So they're certainly under separation of property. If they got married before, you should check if Bangladesh has a renvoi for lex recite. With a complication that can be useful for you, which is, according to some reconstructions, the fact that it is a Muslim marriage, and then the religion has an impact on the civil status as a spouses, may not have an impact on the principle of separation of property. This is related to Muslim regimes which do not allow the community of property, but just the separation of property. And there is no certainty because on the one hand, you have what you just said. religion would be prevailing on everything. And then on the other one, the limitation of public order. And we should see whether this limitation would allow for this. But if they got married after the 29th of January 2019, you can comfortably, so to say, do that because they are under a regime of separation of property. In the first case, you would have some issues, in my opinion. When we sell inherited property, if the dead person had 5 children, 2 are in the United States, we do not know. In Sicilian families, where there was a massive migration, one brother dies without a spouse or children, the other brothers inherit the names of the brothers who migrated are not officially declared. We do not have mathematical certainty in all cases. Some of these cases are more rare, so they're a bit sort of concern for us. The problem exists in many other cases where we are more relaxed because we got a family certificate. It's just like when the bank asks us some details because we do not know if the person who died has children spread all over the world.
Allora, se non ci... So, unless there are other remarks, we might move to the concluding remarks. I wish to thank the interpreters, to thank the speaker. We would like to apologize for being a bit too fast sometimes. Anyway, we would also like to thank those who have been with us online. So thank you very much. Antonio, for you to conclude. Well, I have an announcement before actually concluding. Before you leave, please sign a specific sheet and give it to us together with the questionnaire that you may have filled in before. Thank you very much.